Hi, it's Laurel Dietz of Millennial Legal Coaching, and we're back with another divorce chat. This week, I have Christina Vinters here from Modern Separations. She is a family law mediator, and she's going to talk to us about mediation and how it can be helpful to people going through separation and divorce. So, Christina, do you want to tell us a little bit more about yourself and your background?
Sure. Thanks, Laurel. Thanks so much for having me on the show. I'm a family lawyer, and I have a boutique online mediation practice. It's dedicated to helping couples peacefully resolve the details of their separation. And so what this means is I no longer work in the traditional role of representing one person. I only work with couples together as a neutral facilitator, and I work to help them find solutions that are going to work for both of them.
So that's interesting because I often have people contact me and they, because I'm a little bit of a different service provider than the standard, family lawyer. And so they think, can you represent both of us? I can only represent one half of the party. I'm an advocate. I'm still a lawyer. I'm still acting as a lawyer, even if it's just in a different capacity. So you're a family lawyer too, but your role is the neutral third party. So you get to work with both halves of the couple. Both halves.
Right. So yeah, so although I am a family lawyer and I'm a member of the bar, when I'm working as a mediator with couples, I've got that mediator hat on. And so what I'm allowed to do is provide general family law information, and we can get into more of the role a little bit later. But basically, I can't cross over the line into personal legal advice because then I would no longer be neutral.
Yeah, so you can't provide a strategy to one person and say, this is how you should negotiate this to get a better result for you.
Exactly.
That's something I can do for you. Just before we get into our questions, I wanted to ask you, so there are mediators out there on the roster. There's a few rosters for mediators. One of them is Mediate BC. There's another one.
The ADR Institute of Canada.
Yeah,
is another one.
And I'm curious about the difference, but maybe you can tell us maybe at the end of our conversation. But what's the difference between a mediator who's a lawyer as well and a mediator who is not a lawyer?
So a mediator who is a lawyer in the context of family law, in order to be a lawyer who becomes a family law mediator, you have to take about 100 hours of extra mediation training after you've become a lawyer to be allowed to work as a family law mediator. And in that role, because you have the legal training, you have the ability to draft agreements for people. So a family lawyer who's a mediator can draft that final binding separation agreement for a couple, whereas a mediator who is not also a lawyer, they're allowed to facilitate discussions, but they're not allowed to draft a binding agreement. So the document they prepare is called a memorandum of understanding. And that is basically sort of a summary to say this is what the couple agreed to in mediation. And then in order for that to become binding, then it has to be transferred into a separation agreement by a lawyer or into a court order through the court system.
Okay, so yes, with you, they have the whole process. They can get everything signed, sealed, delivered. And with a lawyer, a mediator who's not a lawyer, they'll have that extra step.
Right.
Okay. So who is mediation right for?
Okay, so mediation is extremely effective for people who are at the point in their separation that they're both ready to make important decisions about their future. They need to feel comfortable speaking to each other in the presence of the mediator and speaking up for what they feel is fair and appropriate in their circumstances. It is voluntary, so both people need to be willing to participate, and they need to be, feeling somewhat flexible and willing to take into account the needs and preferences of the other person. Because it's voluntary, they need to both move a little bit in each other's direction to be able to find that common ground between their two sets of preferences. In terms of some red flags, there are some situations where mediation is inappropriate. And that would be in situations where you do have vastly different expectations and a total inflexibility about taking into account the other person's preferences. With that inflexibility, it's unlikely to lead to a resolution. And then there are cases where there can be severe power imbalances, and that can result from situations like repeated or recent violence, active substance abuse, mental health issues, any kind of issues that would impede a person's ability to be able to effectively participate.
The power dynamic needs to be, that's often what when people come to see me and we're talking about mediation, we often discuss it. So, how is your relationship? How do you feel about discussing these issues now? Do you feel like you can, yes, you see the other person saying like, well, this is how it's going to go. Are you able to kind of push back a little bit on that and be like, well, no, I'm not going to just agree to what you say. And so I'm always looking for that power dynamic difference. And that can come, like you say, with mental health issues or addiction issues or what have you. So, and I thought what was really interesting is that you started that off by saying it's for people who are ready to make decisions about the future. And there is certainly a process people go through, I think, at separation, where when you first separate, like it's sometimes you have a lot of processing to do before you can get to that point where you can say, okay, I'm ready to like move forward and make these final decisions. And even more difficult is that not both people are going to be on the same timeline with that. Have you found that you've had to turn people away from mediation because maybe one party is ready to mediate and the other one isn't?
Yes, that does happen sometimes. Generally, those people don't end up contacting me, so I don't have to. But sometimes there is one person who's absolutely ready to go, and then the other person just is not interested or ready yet to jump into the process. And there's no set timeline. It's a very individual process. Sometimes both people are ready very shortly after making the decision to separate. Sometimes it can literally take years to get to that point. And it seems to depend, obviously, partly on personalities, but also, was it the type of relationship where for years they've been slowly drifting apart and they've now come to the realization that the next phase in their life is going to be better to be separate? Then in that kind of case, they might both feel ready to start making some decisions. If it's where one person has been sort of quietly grieving the end of the relationship for years until they finally make the decision to tell the other person, that can often come as a shock to that other person. And then it takes that person a while to catch up and go through their own grieving process before they can start thinking about any kind of practical decision making.
That's really an interesting dynamic to kind of navigate with people. Certainly, I've helped on both sides. I would say one is the end of the relationship comes as a shock, and then on the other side, where they're ready now, and they're the shocker instead of the shockee.
Right. And I do recommend that the earlier people can have open and productive conversations, the less likely it is that small tensions and anxieties are going to turn into a significant conflict. So as soon as people are ready, it's a good idea to get started. Sometimes people feel they don't need to worry about doing the documentation if there are no big disagreements between them. But actually, when they're getting along is the best time to get the documentation done, because they're in agreement, right? If you delay, sometimes unforeseen things can happen that actually end up derailing that original plan. And then on the flip side, if there are tensions present, they're slowly rising, that is also a good time, again, if both people feel comfortable, dealing with the issue head on to try to get back on track and prevent what can often be a significant amount of time in litigation. So either way, but it's all about the people feeling comfortable and ready.
Okay. Well, I guess that answered my question. At what point should people interested in mediating contact you? But as soon as they're comfortable doing so, I guess. Okay. So I know we've talked about it, but a little bit here, but I really want you to clarify for people as best as you can. What is your role on a file? So when you're in a mediation, how are you helping them through the process?
My role is to provide them the family law information that they need on the various issues that apply for their family, so that they know what are the issues they're supposed to be addressing, so that at the end they end up having a comprehensive agreement. I can help people discuss different options, different ways of possibly approaching issues. I can help with calculating child support, spousal support, if these apply, division of assets, and I can help them have these what are often sensitive conversations. And then at the end, as we discussed, I'm able to draft the separation agreement for them. And then in my particular process, I've created like a fairly directed, streamlined process to help people come in and out of our services as efficiently as possible.
Yeah. Okay, so, and just to differentiate, so you keep saying you provide family law information. So people often, I think they think information is advice. So I maybe we can just talk about the difference between what I'm telling people privately, one-on-one, as opposed to the information you're providing. And so one area that is always, I'd say, often highly contested is spousal support, right? And it's also not super clear, like there's no, this is the way it is. We have no choice, right? There's a lot of, well, this is, specific, it depends on the approach you take. So often I'll say what I tell people. So I'll give people the information first, and then I'll go from there to say, given the facts of your case, this is where I think you should stake your claim. I'm not saying that you're going to get that. I'm going to say this is how you start discussing it, maybe, or how you start saying, like, asserting yourself to say, I'd like spousal support at the high end of the range because A, B, and C. And whereas the opposing lawyer might would say in that conversation, no, you're not even entitled to spousal support. Let's not even think about it. So in your case, you have two people come to the table and you have the topic of spousal support needs to be discussed.
Right. Okay. So on using that as an example, interestingly, often people who come to me, if spousal support is an issue, I would say most of the time, they actually both agree that they either both agree that there is no entitlement or that there is entitlement. So we're not often discussing whether or not it should be paid at all. That does, of course, arise sometimes. The information that I can give them on the entitlement question is, for example, these are the types of factors that would commonly lead to entitlement. But again, I can't say in your particular case, you are definitely entitled to support. I would say if this is going to be an issue, you should both go and get independent legal advice from a lawyer. And so that next time you come back to mediation, you're both feeling prepared to discuss and advocate for what it is that you would like. So that piece is a little trickier, but then the next question is, of course, if there is entitlement, then how much is payable and for how long? And so we use the DivorceMate software, which is standard across Canada, which I think gives people some comfort that it is a somewhat standardized process. Of course, there can be a lot of nuance that goes into choosing the incomes that are used for each person. If they're a straight salaried employee, it's pretty straightforward. If they're self-employed or underemployed, then that can involve a more detailed discussion. So I take people through that discussion, and in the context of mediation, it's their job to agree on what they both feel is reasonable to use for each of their incomes. So I don't tell them what the income should be.
Yeah.
But we walk through the different options, and then of course they can consider the range of support that the software provides.
Yeah. And I think that I like, what you say there is that often you're not actually fighting about whether it should be paid or not be paid. Often people have a meeting of the minds. And I've found that as well, is that sometimes if you just get us lawyers out of the picture a little bit, it can be very helpful to people. Like people are a lot more reasonable. And it was probably in the early stages too, where they both just kind of accept this is the way things are, and we both want to get through this process, and we both feel like this is fair. And I find often clients are going to be a lot more reasonable than their lawyers.
Right. And of course, people are self-selecting into the mediation process. So I generally don't have people coming to mediation with vastly different opinions about what is going to be fair. There are, of course, disagreements and different views on things. But the worst in terms of high conflict cases don't generally choose mediation off the bat.
Yeah. And I think that people always worry they're going to be the high conflict case, but I always try to assure people that actually the majority of divorces and separations, I would say almost 90%, probably maybe go to mediation, but mostly get resolved quite amicably and quite easily. And there's only a very few percentage of cases that ever go either, past mediation through the court process. And so, but those are the ones we hear about, obviously. And those are the ones that lawyers are often a lot more involved on. Okay, so moving forward, how can clients best prepare for mediation once they've decided it's right for them?
Well, the first step would be getting the financial information and documents organized. This is because full disclosure of assets, debts, and incomes is going to be required in the separation agreement in order for it to be considered a legally binding document. And the reason for that is the only way somebody can assess whether they should enter into an agreement, whether it's fair, is if they have the full information. So getting the documents organized is a good start. If the relationship is fairly respectful and not too high conflict, they can certainly start discussing potential options between them. And that's fine if that's going well. One of the risks of doing that before mediation is that sometimes people start making tentative agreements on things when they don't really have the full information yet on what their rights and obligations might be under the law. If the conversation is not going well, if it's creating more tension as opposed to being helpful, then I recommend that they pause discussions until they have the help of the mediator to work through the issues.
Yeah. Okay. And so if you're new to the process, you've just separated, you're like, okay, we know you have to share financial information, and people will span like vastly different, like kind of knowledges of their financial information. So some people know everything about each other's finances, and it's not been a secret in the relationship. Some people have a more traditional where, he or she managed all the finances, and that wasn't their role in the relationship, so they don't really have any knowledge of it at all. And then on some cases, they just always kept their finances very separate, so they don't really know much about each other's finances. So do you guide clients on what sorts of information they should collect and share? Do you make, and then my second question to that is like, do you make sure that they've provided all the information before you go into mediation, or what does that look like when you're in the mediation process?
We have a checklist online that people can use to start getting their documents organized. And it is a term of the agreement to mediate that they sign before they get started that full financial disclosure will be provided. Through the process, we have a client portal that both clients and I have access to. So they each upload their documents to the shared client portal, and then we can all see the documentation that we're looking at. I usually recommend that it's best to try to get all of that provided before we have our first joint meeting, because then we can really dive into the specifics of different options we might be talking about. If they don't have every last document by that first meeting, we put it on the homework list to do before the next meeting. But it does need to be provided before the process ends. sometimes there's some document that for some reason is just they're not able to access. Like, for example, maybe there's an old bank account in the UK that they're having difficulty getting information from. In that sort of case, if both people are comfortable just agreeing on what the value used to be or what they think it is, I'll specify that in the agreement so it's clear that they've both gone into dealing with that deliberately without the information, but in an effort to have the whole process done as efficiently as possible. But for significant assets, we do, I encourage them to have complete disclosure before the separation agreement is finalized.
Yeah. Okay. Well, that's, and I guess that goes a lot to making sure that the power dynamic is fair and the negotiations are coming, they're both on equal footing going into it, not with one person having more knowledge than the other. And I always, because I get clients come to me in all different sorts of ways, and some don't go through the mediation process, they just come and want to do an agreement. And that's one thing that I strongly always urge is like transparency is so critical in these negotiations and discussions. And, especially if you want that, you're putting a lot of work into these agreements to get them done. If you don't want someone to challenge it in the future, that's one of the major reasons why an agreement would be set aside by the court, is like there was, a failure to share that. And so that's, to make a nice strong agreement, you have to share it. And I think some people are shocked at how much sharing needs to happen.
Yeah, some people are unfortunately under the impression that if they've always kept separate bank accounts, then the disclosure of the information is not required. So some people find that a little bit offensive and invasive of their privacy, that all of a sudden they do need to share the information. And I always tell people, you're free to agree to do whatever you like with those assets and debts, but the agreement is not going to be considered binding if the proper information hasn't been disclosed.
Yeah, that's true. Okay. So what does mediation at your bit? So you've mentioned a few times how you have a streamlined process. So why don't you tell us a little bit about your process and your business specifically? How do you differ from other mediators?
Okay, so it's a completely online service, which these days may not be that unique because of the pandemic, but we did actually shift to being completely online a little bit before the pandemic started, because over a period of a few years, I was providing both in-person and online services. And I found that many clients just found it little bit easier to focus on the business of what we were trying to talk about if we were meeting online rather than having them be in the same room together. It takes away a little bit of the emotional triggers that can sometimes still be present for people when they're in each other's company. So we are completely online. We have a range of flat fee, fixed timeline packages, which is nice for people because they're not worrying about what that hourly rate is going to slowly ramp up to. So they know what they're getting when they sign up. And the fixed timeline part of that I found to be really psychologically helpful for people to know that they have an end goal. So our most commonly used package is a 4-week-long package. It doesn't have to take that long, but it gives them up to 4 weeks to get their meetings done and the separation agreement finalized. And having that end date, although they're not stuck at the end if they're not done, we have extensions available. I think it's human nature to not want to have to do an extension. So it helps people focus and have those difficult conversations that might be otherwise tempting to push off a little bit. So that's a little bit of a unique process that we do.
Well, that's certainly, especially where in our business where there's no like it's client directed in the sense that we often are trying to check in with the client and be like, well, you should do this, you should do that, but at the same time it's the client's job to take the next step. And so we've learned there's different types of personalities. There's the anxious personality type who's like constantly contacting and trying to move forward. And then there's the avoider and the delaying personality who just
Mm-hmm.
disappears for months at end with, you can call them, you can talk to them. So it's nice. I think the certainty of the flat fee package is really nice, because then having a timeline really does kind of say, okay, I'm entering to this process. In 4 weeks, we should be done it. Like if we make a push and get her done, then it's nice to have that certainty, because that's the number one question I get is, how long is this going to take?
Mm-hmm.
So
yeah, and so we do very occasionally do the extensions, but the vast majority of people are actually able to get the agreement done within the timeline of the package that they've chosen. We also have a 1-day process, which is certainly not for everybody, but it's for situations where people don't have too much complexity in what they're dealing with. They have a good relationship where they've been able to have detailed discussions, come up with a plan, and essentially need somebody to check that they've covered the important issues, and then provide a properly drafted agreement for them.
Yeah. Okay. And so that covers my last question. How does everything get, actually I have one more. The bonus question was, how does everything get, so if get concluded or wrapped up is you draft up the separation agreement for them. But where do people go from there to get independent legal advice typically, or do they sign right away?
So I'm not allowed to be a witness, and so they don't sign in my they don't sign within the mediation process. I recommend that people get legal advice because that is best practice. It's an important document that they're signing. In British Columbia, it is considered optional, so it will be a legal agreement as long as it's been witnessed by an adult, somebody other than their spouse. So I provide a recommendation that they get independent legal advice, but I also provide instructions for how to sign it if they're choosing not to do that.
Yeah. And if they come back with edits, is that something that you do, the edits of the agreement, or is that something that the lawyers who are asking for the edits would do?
Usually it's something that I would do, as long as both people are still on board with mediating. Sometimes with the lawyer involvement, the conversations can go a little bit sideways. But if they're still within that timeline of their package, they can come back and I can do the edits for them, provided that they both agree on what those changes are going to be. If it's after the package has ended, they can sign up for an extension to have the drafting done. And in cases where they're no longer getting along and they want the lawyers to take over, I will forward the agreement to the lawyer. I don't forward the Word copy to the client because I don't recommend that clients draft their own agreements.
Yeah.
So yeah, part of our agreement to mediate is that they will be provided the PDF copy, but not the working draft of the Word document.
And I would just say, if in my experience, that if you're watching this and you're thinking, oh yeah, I need my agreement edited, if you're able to, it'd be better for the mediator to do the edits than the lawyers, because lawyers have an endless capacity to have different stylistic, wording or whatever, wanting very specific changes, and then it can go back endlessly. And I've been on those files, unfortunately, where it just very small edits end up costing more than the rest of the agreement did. Which is just, nobody really wants that, but it does happen. Okay. Now my bonus question for those of you who are still watching is, there's 2 rosters for mediators in BC. There's I think 2. There's a Mediate BC and the ADR, Institute of Alternative Dispute Resolution. Is there a difference between the 2 rosters?
I'm on both of them, just for the sake of being thorough, but it's a good question. So Mediate BC is a provincial organization. And it was originally the organization which provided the roster of mediators that courts referred to if they were going to be ordering people to attend mediation. That responsibility recently shifted over to ADRBC, ADRBC is the provincial branch of the national organization, the ADR
Okay.
Institute of Canada, and they have now taken over the roster that the judges can use to order mediation. That they will order that people choose a mediator from the specific roster. In terms of, I don't know that it's something that there's a distinction that clients need to be worried about. I think they probably both require similar levels of experience, if I remember correctly. ADR BC and ADR Institute of Canada, they provide additional certifications. So through their organization, I have the designation of chartered mediator.
Okay.
Which I went through that several years ago, and I don't remember the exact hoops that I had to jump through. There may have been some additional coursework I had to do on top of already being considered a family law mediator through the Law Society of BC.
Okay.
But for the purposes of a client, I think finding the key is to find somebody who is specialized in family law. So you don't want to choose a mediator who mediates personal injury issues or something like that. You do want somebody who is intimately familiar with the details of
Well, that's really, that's actually very interesting and helpful for me to know. And then just for anybody, just providing information. So if you are in the court process, there is a way to kind of compel a mediation by filing a notice to mediate. And that's the roster that right now ADRBC is maintaining. So you have to choose a mediator from that roster. I mean, it seemed a little bit counterintuitive to force someone into a voluntary process because the whole point is to agree, but surprisingly, sometimes it can be very effective.
Yeah, interestingly, I have read studies that a forced mediation is almost as effective as a voluntary mediation. There's something about people finding themselves in that opportunity of knowing that if we can just agree today, we can be done with this.
Yeah, so again, knowing we can get through this now, and that's what's so nice about mediation over negotiation is like it's very efficient, and it's these are the steps. Let's go through them together, and someone's going to help make sure we cross off. We check off all the boxes and get it done today. Today or within the month, right? Whereas just back and forth negotiation could go on endlessly.
Yeah, that's right.
So, all right. Well, thank you so much for coming, Christina, joining me. And can you just tell people how they can reach you and how they can find your website?
Oh, sure. They can go to modernseparations.com. And we have a number of complimentary resources on there that people can access. We have a few checklists that I mentioned earlier. There's a copy of my book, which is available for free download. That's called The Pathways to Amicable Divorce. And I wrote that to help people try to avoid the common pitfalls that often occur at the beginning of a separation. And then we also have a limited series podcast called the Divorce Well Podcast and a few videos. So that's all available for free on modernseparations.com. And you don't need to put in an email address or anything for any of the resources. You can just click and download.
That's great. I have access to, I would say the podcast was something I was listening to before, and I found it very useful and very helpful. And I've actually recommended certain episodes to people. So
oh, great.
I do, it is an excellent resource, and I appreciate all the contributions, I guess, you've made to this area. So thank you.
Much, Laura.
Okay. Thanks. Well, if you've enjoyed watching this, please hit subscribe. Please like our video. And if you have any questions or comments, you can put that in the comment box below, I believe. If not, you can send us an email. And that's it. Thank you for watching.
Thanks, Laura.